03 of 2021, state versus Mr. Kgosi Mampuru and 52 others. Your Worship, the appearances today as follows. Presiding officer is Mr. Nchingilo, prosecutor Advocate Jacobson, the defence and interpreter appearances as yesterday, as well as the court clerk to be Ms. Baloy. Your Worship, the case is postponed until today. It was supposed to start at 9 o'clock. The state must apologise. Unfortunately, we parked in front of the magistrates court in Francis Bar, and there were some illegal people parking next to the parking spot, blocking the vehicles. So we had some difficulties exiting the building, but we managed to find the people and travel here. Also, there was some information that was late received, and the charge sheet was compiled. I can inform the court that the accused persons are charged now with 27 charges. The first count being conspiracy to commit kidnapping, and counts number 2 to 27 is charges of kidnapping of all the attendees that attended this meeting. Your Worship, the matter was rolled over until today in order for the state to address the court and to address bail issues. Can the state maybe proceed to address the court in respect of what it has managed to do in the past 18 hours as it pleases the court?
Okay. May I proceed?
Yes, Your Worship. I need to mention and thank the task team of the Hawks that really went the extra mile. I don't think one of the members had an hour's sleep in, but not all of the addresses has been managed to be confirmed. Unfortunately, some of the addresses have not been yet attended to. But there are some people, and I did address or discuss it with the defence, and maybe the state would like to make the following suggestion in light of the findings of the state and in light of the status of the case. I must inform the court also that just before the proceedings today, the brigadier handed the profiles to the IO of all of the members, all of the accused persons rather, and it does appear that some of them will be a Schedule 5 bail application, because they are facing Schedule 1 offences here before this court, but with the previous convictions or cases for which they are out on bail, I know that there's one specific accused that's out on parole for murder. Those need to be dealt with differently. It will be a Schedule 5 bail application, the state would suggest, and maybe those just set apart at this stage. I can't tell the court the exact number, as the IO is, as we speak, busy going through the profiles, but I understand the range is between 9 and 11 people for which there will be a Schedule 5 bail application. The interpreter, can you just translate that? Thank you, Mr. Simuloni.
Lapha ezifika zokushishisa bachaza kena kuchazela inkantolo ukuthi abumangalela abangelanga phambi kwenkantolo bazobhekana namacala angafika emacala 27, kanti ke nabafikile ukuthi bachaza futhi ukuthi kulesi sikhathi lesi abaphe sona izolo amahola awu-18 bathi bachaza kena ukuthi khona kena abakwazile ukuthi bakwenze, kanti mayelana namakheli wabo umangalelo bachazela ukuthi abakwazanga ukuthi baqiniseke wonke amakheli wabo umangalelo labalanga phambi kwenkantolo, kanti yena lo okudlula icala nophethe icala uhlasebhizi.
Can someone tell the people who are in the corridors here? I hear their noise. It's disturbing. Okay, we proceed.
Lokho kungulicala ubhizi manje usaphenyana kena nemininingwane yabo umangalela la abalanga phambi kwenkantolo ukuthi kena bazokwazi ukuthi bathathe isinqumo sokuthi emuvi namuphi umangalela yiphi icala ukuthi bambeka ngalo. Chazile futhi ukuthi khona kena omunye wabumangalela ukuthi waphuma ngeparole okungukuthi bekabhekane necala lokubulala kanti yena bazama ukuthi bakwazi ukuthi yena bathole ukuthi yini okungukuthi icala lakhe lizoba yi-schedule 5 okuchaza ukuthi icala kena lelo ozobe ubhekane nalo lizoba elinye lamacala amabi ngoba umuntu mhlawumbe usuke waba necala eliningi ngaphambilini ngiyazwisisa. So yiloko-ke lapho ezokusheshisa abakuchazayo ukuthi ubaba lokhu kungena icala usabhizi ukubhekana nemininingwane yakumangalelo.
As it pleases the court, Your Worship, the general consensus between the defence and the state is that maybe the best way forward is to dispense with the people, the accused persons with which the state does have no objection against bail and whose addresses has been confirmed. On looking at my list, and it seems to be seems to be 13 people at this stage for which the state has confirmed addresses, and there is a bail form completed for them, and they do not have previous convictions, and addresses has been confirmed. The state doesn't want to leave Section 7 of the Kokatoro Act just in the air, Your Worship. The court will note that it hasn't been put as a formal charge on the charge sheet. The charge sheet has been completed. There's 27 charges. That charge is not totally off the table. The state is still in consultation with the NDPP, but apart from the DPP, it needs to be forwarded to the NDPP's office for a certificate, and unfortunately that the time span hasn't allowed for such a certificate. So my instruction is to proceed with the bail application being as a Schedule 1 bail application for this purposes, and then later on the state will still deliver it in respect of the Poktatoro relevant section the state submits. Your Worship, in respect of the 13 people that the state can proceed with, it's a state submission that I don't think it would be necessary that the court can provide guidance in that regard. Since bail forms has been completed by the investigating officer, which is indicating that the basis was confirmed, no previous convictions or pending records, that the state would suffice. Maybe the defence can make submissions in respect of the 13 people, and then maybe we can stand down after the 13 has been dealt with, so that I can just liaise with the investigating officer in respect of the profiles of the rest, and I can address the court properly in respect of the rest of the people, if the court finds that in order.
Okay, it sounds in order.
Thank you, Worship. I will then proceed with accused number 1, Kgosi Mampuru.
Okay, just before that, for completeness.
Yes, Your Worship.
The charges here, as the charge sheet has been completed, it looks like from one is conspiracy to commit kidnapping.
Indeed, that's
count
to 27 is kidnapping.
It's kidnapping.
Deputy ministers that will be deprived of their freedom inside that room due to the barricading. Yes,
yeah, I wanted that to be clear on the record.
Thank you, Worship. Indeed, that's the charges. Can the state then proceed in respect of the non-opposed bail applications? In respect of Kgosi Mampuru, I'm going to address the court, Your Worship, to say that it seems that the accused has no previous convictions, and he has also no outstanding cases. His address has been confirmed.
Okay, so when the name is called, can you come forward?
Mr. Kgosi Mampuru, just stand in front. Thank you. Maybe I can call all 13, Your Worship, they can stand in front so that, because it's the same submissions in respect all of them. Okay, so it's Kgosi Mampuru, accused 1, let him stand here, yeah. Next to him, Joseph Mtembu. Next to him, please. Then Aaron Mahue. Abel Sikele. Abel Sikele number 4. Oh, it's accused 12, but I will tell the numbers of the accused persons to the court just now so that the court can note it accordingly. Muzukizi Runayuza, case number 15. Johannes Medise. Tabiso Mashia. Sibusisu Mazibuku. Kleinroy Marinsela. Chris Dakile, Chris Sipu Dakile. Joseph Simelane. And Dumasani Timahu. And Alfred Seatlafan. So it's 1, 2, people, Your Worship, that's here in front of the accused dog. Kgosi Mampuru is noted as accused number 1 on the charge sheet, Your Worship. So it's accused 1. Joseph Mtembu is accused 2. Aaron Mahue is accused 8. So it's 1, 2, 8. Abel Sikele is accused 12. Muzukizi Runayuza is accused 15. Johannes Medise, accused number 19. Tabiso Mashila, accused number 29. Sibusisu Mazibuku, accused number 30. Kleinroy Marinsela, accused number 32. Chris Dakile, accused number 41. Joseph Simelane, accused number 51. I'm sorry, these are not in sequence, Your Worship. There's 2 extra. Dumasani Tamayu, accused number 42. And Alfred Seaklane, accused number 49. In respect of all 13 accused in front of the Dark Your Worship, the state has no objection against bail. It's a Schedule 1. The purpose of bail is not whether the accused are guilty or not guilty. It's a matter of whether they will be able to stand trial and whether the society out there will be safe if they are released on bail and whether the interest of justice permits and if the state can prove the contrary. So it's a state submission that the state doesn't have an objection against these 13 gentlemen or accused persons. In respect of bail, the addresses has been confirmed. They have no previous cases, no pending matters. No, it's not the same. It is a 4%. I'm sorry, Your Worship. It seems that there is another suspect which we did not have a problem with. If the court can just bear with us for a second. I just want to make sure Zumisi is one of the in front people. Zumisi. Sorry? Muzukisi. And the seller? Accused number? Yes, Your Worship, if Mr. Ronyaguza can just remove or go back to the back, because it seems that he does have a record. It's Muzukisi. Muzukisi Ronyaguza. Accused number 15. He's in the back.
Yes.
Yeah, okay. Accused number? Accused number 26, and the court just confirmed whether accused number 26 on the charge sheet is Samuel Mokayandu, not Chantambu.
Yes.
Accused number 26 can come into the front, and Muzukizi must go to the back. Thank you. So Muzukizi we will deal with later. It seems that it will be a Schedule 5 pilot section, and we are joined now by Ms. Samuel Chacham. Your Worship, in respect then of these 13 accused persons, and not the previous one that was rectified, the state doesn't have an objection against bail. It seems that they will be traceable for the investigating officer to locate. And it seems from the previous conduct that there shouldn't be a problem or a reoccurrence of a Schedule 1 offence based on their records. So the state doesn't really have any ground to object against bail against these 13 accused persons. The state is of the submission that they do not stay in the area. They do come from a distance. I think most of them are from Vaal and around Gauteng. But it's the state submission that even though it is a Schedule 1 offence and the state doesn't object, that there must still be an amount of bail fixed in order to secure their attendance for the next appearance, and the state would suggest an amount of 2,000 rand for each one of these accused persons. The court then rectified that it's not accused number 15, but accused number 26, that's before court then. And then indeed, in terms of bail, the state has no objection against this 13 accused people getting bail, as it pleases the court.
Thank you very much, Your Worship. Your Worship, we had some preliminary discussions with the state. For practical purposes, we have agreed to deal with the matter in these different stages, or these three categories. First category being the category that is in front of the court right now. Second category being the Schedule 5 category, people who fall under that. And then the third category is the category of people in respect of whom no addresses have been found in the time allocated by the court. If the court can just give me 1 second. Thank you, Worship. I appreciate the time. Sorry, Worship. The investigating officer informed me of some information, but I wanted to check with my learned friend first whether I should relay it to the court. Looks like it will be relayed at a later stage. In any event, then the third group is the group in respect of whom the addresses they've failed to secure the addresses, even though the court gave a generous time which was more than the 12 hours allowed by the statute. We will address the court at the right time in respect of that group. So for now, Your Worship, I will then confine myself to the group of 13 who are in front of the court. Well, of course, we welcome the fact that bail is being granted, but we are of the view that the amount amount that has been proposed is too high. It's excessively too high. Your Worship, these are persons who, in respect of whom, quite frankly, it's still not clear even today what they are charged with. It doesn't help to just give us 27 counts now, which are still the same as yesterday. All it means is that they've now counted that there were 27 people in the room, but it's still one charge of so-called kidnapping. We don't even know whether those people might even include some of the accused. So that's the first thing, Your Worship. There's just so much uncertainty around the so-called offences. But more importantly, Your Worship, the state is fully aware that what we are here about, and we will deal with that in detail in respect of even the second group, is at best on all versions, on their version and on our version, was a meeting which went sour at a certain stage, but a meeting at which all of these people and the other so-called victims had volunteered to gather. And the version, when we do present the affidavits, if we get to that stage, the version will be that all that has happened here is a protest at West. People were protesting, and protest by definition is disruptive and it inconveniences people.
Okay, Advocate, let me redirect you a little bit. I need to hear about the amount.
Yes.
If we are not objecting to that, suggest an amount, and then maybe I would want to hear your reasoning behind the amount.
Yes. Well, okay. Well, either way, Your Worship, it's fine. I'll then let me mention the amount, and I'll come back to the motivation. Well, in our respectful submission, because the majority of the persons are unemployed, and in fact the reason why they were protesting, that's what I was coming to, towards the amount, was exactly because they wanted money, and they were, because of their destitute situation. We proposed, therefore, Your Worship, that purely for really symbolic reasons and to ensure that they do attend the court, that the amount should be fixed at 500 rand each. That those are our instructions, and the part of the reasoning for that is what I've already said, but also for the fact that this whole entire business is just ill-fated and ill-conceived. Secondly, Your Worship, as we all know, I don't have to lecture Your Worship about the purposes of paying is simply to make sure that the people do come back to court. Well, I can assure Your Worship that none of these people, if anything, they want to come to court more eagerly than anyone else, because they want to make their plight that they've suffered for the past 27 years to be known. So the last thing they want is to disappear. They actually want, if anything, they should be, if anyone wants to pay money, they should pay money to keep them away. They won't even be able to do that. In other words, the bail, as we all know, in this case, will simply be as insurance, symbolic insurance, as I say, that they do come back. But there's not a chance in a million years that they will not honor their appointment with the court. That's correct.
Bishop, can I quickly reply on what the defence said? As it pleases the court, Your Worship, the reason why the state requests a certain amount to be fixed is the court must also think of the magnitude of prosecuting 53 people, and if one person doesn't decide to come, the rest must come again, and it becomes a tedious process to secure 53 people each time at court. So the state would suggest that to make it really imperative for them to attend court, the state would suggest that bail be fixed, at least to secure that they do attend court. In respect of the facts, the state's submission to address the court in terms when we come to the Schedule 5 bail application, since we didn't have any objection here. If the court wants the state to address the court on the facts, it's the state submission, of course, that this was not just a type of upset about a meeting going the wrong way. This was a malicious conduct on behalf of the accused persons. They were in fact represented inside by 10 of their members, and definitely the 10 members are not amongst the complainants in the case. The complainants' names are revealed in the charge sheet. It's generals, doctors, ministers, deputy ministers that were being held hostage because they did not get their way or their outcome. Your Worship, if every institute in this country takes the stance and keep people hostage of that magnitude or of that importance, where will this country go? What will happen to us? If everyone that's unhappy about a certain situation, if there's not a format, already a format was created, they were accommodated to facilitate a meeting with a certain task team, and even though the president or the deputy couldn't attend, he delegated to the Minister of the Presidency, Minister Gungubelu, who attended the meeting, and they didn't want to accept that. And then they barricaded the doors. The 10 delegates found the 43 outside, they came inside, they barged in, they blocked the doors, barricaded the doors, and a lady wanted to go outside just to use the bathroom. She was not allowed. So definitely it's not just a progress or a protest going wrong. It's a state submission, it's a strong case, but in terms of the bail, an amount to be set for purposes of securing their attendance, as it pleases the court.
Okay, just one question.
Yes, Your Worship.
For me, this is still the what's called the thinking behind bail.
Yes.
Is there any evidence that the state has against the state in here that the state would say this one actively did this amongst these 13 to associate him or herself with the kidnapping?
Your Worship, it's a state submission, like I said, indicated yesterday. The state is relying on common purpose. The fact that 43 people were called outside and called inside, and all of them, some went to the doors, others went to the other doors, others sang incitement songs. So all of them, if there was 3 or 4 of them that we could not say they didn't associate them with the others. In terms of association, in terms of participation, I can't inform the court at this stage that accused number 1, Mr. Mampuru, was the one that or shouted at the minister. The videos need to be analysed for that, and for that the state needs time, which it wasn't granted. So at this stage we can't say accused number 1 did this, accused number 2 did this. We are relying on common purpose and say that everyone was actively involved, and conduct can be imputed by virtue of common purpose doctrine, as it pleases the court. The interpreter, Your Worship.
Yes.
Emva ukuthi ummeli lapho ezidinga ukuthi ummeli yena lapho bezidinga into yena abayibikela inkantolo ukuthi isizathu sokuthi intengo lena iyebheli ukuthi ize phezulu kangaka ukuthi bazokwazi ukuthi baqiniseke ukuthi bonke kena abasola laba kena bayaza kena ngaphambi kwenkantolo ngazo zonke insuku ukuthi bazodinga ngazo ngoba kuzobe kuba inkinga mangabe omunye wabakezi ukuthi bakwazi ukuthi kena bathole omunye ukuthi bazokwazi ukuthi baqhubeke ngecala. Kanti futhi kena enye into abayibekile ukuthi impatho lena kuyimpatho kena engalunganga ngenkathi kwenzakala isehlakalo, hayi ngale ndlela lena ummeli wenu kena ayifike ngayo ukuthi ngokumhlangano okungukuthi kena awuzange wahamba kahle. Kanti futhi kena bachazile futhi kena ukuthi ngokunama-minister kanti nama-deputy minister kungukuthi laphana baye bagcinwa ngaphandle kwemvumo yabo ngokhona ke nomunye wabo kungukuthi akazange avunyelwe ukuthi aye endaweni kanti ke nabathazile futhi kena emva kwalokho kena bese inkantolo kena yasekena ibabuza kena nabezophiko lwezokusheshisa njengoba beyibuzile nangaphambili ukuthi ngabe yini into okungukuthi ubufakazi abangaveza ngaphambi kwenkantolo ukuthi umangalelo othize yilokhu akwenzile ngenkathi kwenza isehlakalo, loyana othize yilokhu akwenzile ngenkathi kwenzakala isehlakalo. Mabaphendula lapho ezophiko lwezokusheshisa into abayishoyo ukuthi into bona abasekela kuyona yilokhu ukuthi leli cala ngenkathi lisala lidala ngomqondo owodwa. Angeke kwamanje baze bakwazi ukuthi baphawule ukuthi umangalelo othize indima ayidlalile ngenkathi kwenzakala isehlakalo indima thize. Kodwa ke into abasayidinga ukuthi bahambe bayohlaziya kena amavidiyo footage ukuthi bazokwazi kena ukuthi babone ukuthi umuphi umangalela oyenze into ethile ngaphambi kokuthi kena bangaletha kena ubufakazi kena obugcwele mayelana nalokhu ngaphambi kwenkantolo. Ngiyazwisisa.
Judgment, the state is not proposing bail in respect of the 13 accused who have been pointed out and they are before court in front of all the other accused. They are not standing in any order. At least their numbers as shown on the charge sheet would reflect who they are. The bail is not proposed in their respect. The issue then becomes the amount of bail that should be ordered by the court for payment by the accused.
labo bamelanga kwenkantolo ngaphambili kanti kena into nje kuphela okungukuthi kena kuphikiswana ngayo indaba yentengo kena noma imali lena eyebheki kena evezwe ekhishwe lapho ezophiko lwezokusheshisa kanti ukuthi inkantolo kumele kena ithathe isinqumo mayelana nalokho.
The prosecution suggested 2,000 rands as bail to ensure that the accused persons do attend court.
Abezophiko lwezokusheshisa bacelele ukuthi inkantolo ibakhulule ngebheki 2,000 rand ukuqiniseka ukuthi kena abamangalelwa lapho bayakwazi ukuthi beze ngaphambi kwenkantolo.
The reason indicated by the prosecution in this regard is that there are 53 accused persons who would be required to attend court. If one of them stays away, the court process then gets hampered.
Kanti kena isizathu sabalapho ezophiko lwezokusheshisa ukuthi abomangalela masabaphelele bawu-53 kanti omunye wabo mangeke aze ngaphambi kwenkantolo baye besaba nenkinga ukuthi baqiniseke ukuthi bamthole ukuthi bamphinde aze nangaphambi kwenkantolo.
The defense indicated that each of the 13 accused would only be able to afford 500 rand as bail.
Kanti kena abameli kena baphawule babekela inkantolo ukuthi imali okungukuthi bangaba sesimeni sokuthi bayikhokhe yebheli imali engango-500 rand ngamunye ngamunye.
They are indigent and they were there to try and get some money because of the situation they are facing.
Kanti bebalaphayana banesikhalazo sokuthi kena banikezwe imali ngesimo abakuso.
If there is no agreement between the parties as to the amount of bail, eventually, if the court does not grant the amount suggested by the defense, then the court will then have to hold an inquiry regarding the affordability of the bail amount in any region above 500 rand.
Yena mangabe kena isimo sikanjena akuvunyelwana kena mayelana nemali ekhishwe ebekwe yilapho ezophiko lwezokusheshisa yebheli inkantolo kena kuyaye kena ukuthi kumele ifune ukuthi ibambe kena uhlelo kungukuthi izokwazi ukuthi ithole umniningwane futhi ngabe basesimeni noma besesimeni sokuthi bangakhokha yini abafaka isicelo lapha imali engango-500 noma engaphezulu.
That would be a cumbersome process. It would be a very long, dragging process, very cumbersome.
Kanti lolo hlelo lolu hlelo olude kakhulu.
When there's no objection to bail, then the court will have to lean over backwards to ensure that everyone who's applying for bail should be granted an amount that he or she can afford.
Mangabe yena akuphikiswa ukuthi yena abafaki icelo kena ukuthi bangakhulula ngebail. Inkantolo into kena engayenza ukuthi iqiniseke ukuthi yena ibanikeza imali yebheli ukuthi basesimeni sokuthi bangakwazi ukuthi bayikhokhe.
If it is not done that way, it will amount to a refusal of bail.
Mangabe inkantolo ayenzi lokho kuyobe sokufana nokuthi inkantolo iyabanqabela kena ibail.
Taking into account the circumstances of the case and that at this very moment the state is unable to indicate what part did each of these people take in this hostage drama is concerned. The court takes that into account as well.
Kena inkantolo engachaza ukuthi njengoba izothathela kena emqoka kena isimo seqala kanti nalokho ukuthi lapho izokole zokusheshisa bahlulekile ukuthi bachaze ukuthi indima yomuntu omunye nomunye ayidlalile ukuthi beyiyiphi ngenkathi kwenzakala isehlakalo.
The state has indicated that it did not have enough time to go through the video material to identify individuals as to what part they took.
Ezofikele zokusheshisa bachaze ukuthi abazange babe nesikhathi esanele ukuthi bahlaziye ivideo footage lelo ukuthi bazokwazi ukubona ukuthi yiphi indima abumangalela bayidlalile ngamunye ngamunye.
It is my thinking that the process of their arrest and detention could have been handled in a better way than how it was handled.
Kanti mina sengibonile ukuthi ukuboshwa kwabo nokugcina kwabo ngaphakathi enkampini zesiphoyisa abamangalela laba beyingaba beyikhona indlela engcono yokuthi bebangakwenza lokho.
It is understandable that they may have had to detain everyone who was there, who may be identified as one of the people who attended the meeting as NKVA or whatever, whatever they are called, and then detain them. One can understand that. Detain them for purposes of investigation.
Ngazwisisa ke ukuthi bebasesimeni sokuthi bokumele ukuthi bakhokhe wonke umuntu ukuthi bekalaphaya emhlanganweni okhonjiwe ukwenzela ukuthi babagcine enkampini zesiphoyisa emva kwalokho kena bese base baqala ngophenyo lwecala.
Then the thinking should have been from there on is, okay, some of these people may not be wrong, may not have acted wrongly. So how do we distinguish between the people who acted wrongly and people who acted, did I say wrongly and rightly?
Ngakho umcabango ngokumele ukuthi ube khona ukuthi kena uqale ecatshanga ukuthi kena ibapha abantu ukuthi baye bawonile nabantu ukuthi abawonanga.
The intention should have been, if there is anyone here who is innocent, let's get these people away, out.
Ukuthi bakwazi ukuthi mangabe khona ukuthi umsula umuntu kena bayenza ukuthi bamkhiphe.
Not to keep everyone there for 3 days, 4 days, or even try to keep people for 7 days or 14 days or for whatever days.
Ukuthi bagcine umuntu laphana phakathi iy'nsuku ezine ezinhlanu eziyisikhombisa kanjalo kanjalo.
this footage should have been watched exactly on the day or the day thereafter, if whatever. And then from there you'll be able to identify this one did not do wrong, this one did not do wrong, and then you excuse those people, you release them, and you are left with the culprits.
There video footage bakumele ukuthi ikube ngalo lolu suku lemva ukuboshwa kwabo noma ngosuku olulandelayo emva kalokho bese kuthatha isinqumo sokuthi lona uwonile lona akawonanga.
It is unbecoming that how many days down the line, I've even forgotten how to count. So many days down the line, the video footage has not been viewed for the purposes of releasing people who are possibly incarcerated wrongly.
Kuzofika namhlanje i-video footage lena ngazi nokuthi insuku ezingathi kodwa i-video footage lena ayikakabukwa ukuthi bakwazi ukuthatha isinqumo sokuthi ibaphi ukuthi bawonile.
Taking everything into account, as I've indicated, the court believes that the amount of bail should be 500 rands so that it is within reach by all these 13. Bail is set at 500 rands for each.
Does the court necessary?
I-bail kena kumanje ngango-500 rand ngamunye.
Okay, do we have a date?
Bishop, can we just quickly raise you for the offense? Let's just look out it. We've done prices on the so you make it 26. On 1st of February 2022, Your Worship.
Okay.
Your Worship, the court
That is
will
for
be
investigation.
court 16.
Court 16.
Yeah, it will go to court 16 then. Arrangements will be made if it's different because it's a Tuesday and that court is not, this court is not sitting, and obviously they are going to be from bail.
Yeah.
Yes, so it will be 62.
Court 16.
16. 16 is the court rule.
Confirm the date.
Okay, your case, the 13 here, is postponed to 1 February 2022. That will be in Court 16, Pretoria Magistrate Court.
Iqala lezohlise mhlaka 1 February ngonyaka ozayo ngo-2022 e-court number 16 e-Pretoria Central Magistrate Court.
If bail is paid, as I've indicated, bail is set at 500 rands. If you pay bail will be released, you then have to appear in this court, Court 16, 8:30 in the morning on 1 February 2022, and you remain in attendance until your matter is dealt with on that day. If you're late or you don't come to court, or you leave early before your case is called, a warrant for your arrest will be authorized. You'll be arrested, kept in jail until the case is finished. You'll be then charged with failure to comply with bail conditions, which comes with a fine of up to 40,000 rands or imprisonment of up to 2 years. Do you understand?
I-bail i-500 rand mangakhokha qiniseke ukuthi ngiyafika nge-1 February ngonyaka ozayo 2022 e-court number 16 ngo-8:30 elafana e-Pretoria Magistrate Court. Kanti nazi-ke ukuthi kuzomele ukuthi nihlale e-court icala leli lize libizwe, kanti akumelanga ukuthi umuntu ahambe icala lakhe lingakabizwa. Kanti-ke namangabe-ke nakwenza lokho ukuthi umuntu ahambe noma ungezi ngaphambi kwenkantolo, sizogcwalisa imali engango-40,000 randi noma ubhalele ngaphakathi ejele iminyaka emibili nazisisi.
Okay, I think they can be taken out, or should I attend for them to be taken out?
We should be, the prison can assist us to take the 11 out, but the court can adjourn at this stage. I think that the 13 that has been dealt with can be taken to the holding cells. Please do make negotiations for both. No. I've already identified 4 more people that we can deal with, Your Worship, but I need to liaise with the IO. So, if the court can just adjourn at this stage. Your Worship, there's just an aspect of that accused that wasn't present yesterday. I don't know if the court had held the warrant over until today, but I got another sick letter for today. So